Order. Thank you very much, Lord Ahmed, for joining us this afternoon on our session, the Foreign Affairs Committee's session on overseas territory. And thank you very much, Mr Merrick, for joining us as well as Director of the Overseas Territories. Mike, can I ask you to start, please?
Yes, before I ask a question, welcome you. Can I declare an interest as the Chair of the All-Party Parliamentary Group on Anguilla? Now, I'm going to ask some questions about the Sanctions and Anti-Money Laundering Act. Minister, as you know, this has been a bit controversial with some of the overseas territories, and it requires them to publish registers of beneficial ownership by the end of 2020, or, if they haven't done so, to be forced to do so by the UK government using legislation, orders in council, presumably, to bring that about. Can I ask you how many overseas territories have published registers of beneficial ownership and which have yet to do so?
First of all, thank you. And in terms of the, if I could just say on the legislation, first of all, the obligation is on the government, Her Majesty's government, to produce an order in council if a territory does not have a public register by 2020. In terms of those that are targeted to have a register by 2020, for example, Gibraltar is one such territory. And it is our intention, certainly during the Joint Ministerial Council, we made it very clear that we will, number one, work with the territories themselves. And it is our intention that if by 2020 there is no, for whatever territory that doesn't have a public register, we will then issue an order in council, which will then have a requirement for an operational public register by 2023. Now, the Sambler Bill itself is quite specific on the obligation to the government to produce an order in council on those territories that by 2020 don't have a public register. And therefore, what we've made clear to all the overseas territories that attended the JMC, and I'm in the process of confirming that in writing to them, will be then obligated to produce a public register, an operational public register by 2023. That is the current timetable.
Getting back to my question, how many of the overseas territories have yet to publish those registers?
The only one that I'm aware by 2020 will have one is Gibraltar, but all of them will be required. None have public registers.
None have yet?
None have yet,
yeah.
and we're going to be working through technical means and legislative means to help them in terms of getting those registers.
When you say technical means, what technical means is that?
Well, so for example, that includes the technology in terms of public registers. The UK has already been through the process of getting our own register available, and so it's about actually sort of making sure the information is centrally held, but also so it's publicly available and so on. So these are the kind of technical things.
So this is computer IT technology?
Potentially, yes. I mean, it depends how exactly the registers would work. We've already done quite a bit of work with the territories in terms of the beneficial ownership agreements around law enforcement cooperation to make sure that the information is actually available for law enforcement purposes, so it's building on that.
And you said legislative means, what would that involve?
So that's making sure that the necessary laws are drafted and passed so that the registers are established and made available. Clearly that'll build on our own experience, and we have colleagues in other departments who worked on that and then BAYS. But also part of it is just the basic drafting to make sure that all this is done properly. And we provide quite a lot of legislative drafting support on a number of other areas, so it builds on that as well.
So, sorry.
Clarification, sorry, forgive me, you said 2023. The law said 2021.
No, the actual order in the legislation, the bill, the Act, actually obligates the obligation is on Her Majesty's government to produce an order in council by the end of 2020 on those overseas territories that don't have public registers. Through working through the mechanics of that, we have made it clear to the overseas there's no specified date on when public registers will be operational.
So to be clear then, following that up, you would be allowing them a further 3 years to comply with the legislation?
Well, first of all, the legislation, as I said, the obligation is on the government to produce. Some may comply anyway, and it's our view from our discussions that, for example, Gibraltar will have a public register by 2020. The other reason, if I may just build on a couple of points that Mr. Merrick made, first of all, the point of having already arrangements in place. One of the contentious issues during the workings of the bill, and which then became the Act, was the fact that many, or in particular the likes of the BVI, the Cayman Islands, had working exchange of notes practices, which fulfilled, certainly from the government's perspective, the requirement to allow excuse me, tax authorities as well as law enforcement agencies access to these registers. So a lot of the technical work has already been enhanced. And the other point is we have made clear to every territory whatever support they need in terms of technical support and resourcing, we will assist them in setting up committees between ourselves and each territory to ensure that they are ready.
Thank you. I know that the Anguillan government has said that they have no problem with doing this, and they are working with you to get the technical means to make that possible. But we've had evidence to our committee from some of the other overseas territories representatives, for example, the British Virgin Islands, and their representative robustly made clear the position of the BVI government, and they're on the record. In fact, their Deputy Premier, Mr. Kedrick Pickering, told a crowd demonstration in May that we recognise that while we stand here today, we have declared open war against the United Kingdom. How's that war going?
Well, first of all,
where are we now?
there is no war as such. I think there were emotive statements made at the time. I've spoken to Mr. Pickering twice since that statement. I think it would be fair to say that through my visit that I made to BVI, certainly he has found that the constructive attitude of the British government subsequent to that legislation passing, and I think it would be fair to say there is no war, but equally there are strong sentiments in the British Virgin Islands. And if I may, Mr. Gapes, on that, what I've sought to do is not only engage directly with the government, but I've also sat down with the financial services industry there to ensure that their views are also reflected in the public register. In terms of the requirements, we've also been very clear that the law has been passed and there is a requirement now for public registers in all our overseas territories, and we've outlined the steps the British government will be taking, ensuring we fulfil our obligations in that respect.
Okay, so do you expect the British Virgin Islands to comply with the law?
I would expect every overseas territory to comply with the law.
Yes, I was just going to add to the Minister's point. I was in BVI myself in early November and spoke both to the Cabinet and to BVI Finance, the sort of industry grouping. And whilst, as you say, back in May, people were unhappy at what had happened, I actually detected a reasonably constructive tone. People still wanted to find out what the situation would be, but certainly BVI Finance were thinking through what this would mean for industry and so on. So, as the Minister says, we will work with all the territories on how to take this forward.
Okay, can I go on to one other territory, which is Cayman Islands government has said that the Act offended long-standing constitutional conventions, and in a written submission to our inquiry, they've actually say they wish to discuss sanctions against members of Parliament, committees or all-party parliamentary groups who malign the Cayman Islands. What's your response to that?
Well, first of all, our relationship, I would argue, with the Cayman Islands, and I hope Premier Alden McLaughlin would also reflect the same sentiment, is a very positive and constructive one. Indeed, on a separate issue which resulted as, because of the passing of the legislation, we've had very constructive discussions, most recently at the Foreign Office and a team from the Cayman Islands, including the Premier, on issues of the Constitution. In terms of where we stand currently with the Cayman Islands, there is an active exchange of notes process and procedure underway, whereby, as I said earlier, any law enforcement agency or indeed tax authority has access within the space of 24 to 72 hours.
So that's not public register?
No, it's not public registers. But our point is very clear in all discussions. There was, understandably, and I want to be very clear, as I have done with the committee at all times, when this legislation was being passed, I certainly, as the Minister who took the legislation through the House of Lords, and as the Minister for the Overseas Territories, was very clear that I believe that the exchange of notes that we're operating, particularly with those territories who are directly impacted by this legislation, were working. There was a good, sound, constructive relationship. However, it was clear to the government that the sentiments in the House of Commons was not reflective of ensuring that legislation or the government's position would carry. And that's how this particular amendment was made to the Sanctions Bill. However, we have to respect the authority of Parliament. That point has been made clear to the territories, and I think they're also respectful of the constructive attitude we've taken in discussions with them on ensuring that these public registers are operational, but also for allowing time for these public registers to become operative.
But not in 2020?
As I said, the 2020
23.
obligation. If there is a territory that chooses to have a public register by 2020, all for the good, but the obligation is on the UK government at that time, at the end of December 2020, to produce an order in council. I would also add there are differences with constitutions. So, for example, in Bermuda, there is a legal issue there whereby the constitution, the order in council, may well have to be instituted by the territory itself. So there are different constitutional arrangements as well. But the obligation is on the government to produce the order in council. But in terms of the timeline set, which I may be preempting a further question, why 2023? Under Mr Cameron's government, that was the date which was set as our priority on ensuring worldwide obligations on adhering to public registers across the globe. And we feel the 2023 deadline provides an appropriate target date.
But we're not waiting for a worldwide agreement?
No, we've made clear that we will continue to lobby through all our representatives, be it through representations through G20, G7, any opportunity we have for global standards. But we've also made it clear there's an obligation on Her Majesty's Government to produce an order in council, and we expect all overseas territories to have public registers by the end of 2023.
Okay.
Just to declare my own interests, which are registered in the members' interests on overseas territories generally. Minister, I realise this is now the law and the government have to enact the will of Parliament on this, but are you satisfied that the new rules coming in, which will directly affect overseas territories, are you satisfied that this is a level playing field for all parts of the British family? Is the United Kingdom following the same strict public register as the overseas territories or the Crown dependencies also going to follow that? And if not, is that really fair? And aren't we just perhaps harming the potential for the overseas territories to prosper, and maybe business will go elsewhere outside of the British family?
If I may, Mr Chairman, on the final question, I think we've certainly alerted, and when I was in the BVI, for example, and the Caymans, and made clear that if there was a concern or indeed evidence of a flight of assets to other territories, we should be alerted to that. That hasn't been the case. On your specific point, is it the same for the whole of the British family? Well, first of all, we have a public register in the UK. However, your point on Crown dependencies is also correct in that Crown dependencies are not obligated to follow these rules. There was, as you may recall, during the passing of the legislation, an amendment which was also suggested that this public register rule should apply to the Crown dependencies, but it didn't secure the support in Parliament, and that's why that particular element of the British family is not covered. In terms of, from a global perspective, whether there will be a level playing field by 2023, as I said, that's an objective and ambition we've set ourselves. But in terms of, in my personal view, whether we will see every territory across the world having public registers by 2023, I don't think that will be the case.
But you're sure the overseas territories are going to follow the same rules that we follow? So our rules are not going to be weaker than theirs. We're not imposing something on them which is stricter than what we ourselves are actually using in the United Kingdom.
I think the framework of our discussion is reflective of as Mr. Merrick said a few moments ago, that we've already created these mechanisms. But we've also said to them very clearly if there are particular nuances to their own respective territories, and also respecting the fact that our different territories impacted by this legislation depending on the nature and the development and the size of their financial service industry. We have to reflect that. But the actual framework of that legislation will reflect what we apply here in the UK. I don't know if...
I was just going to add a couple of points. I mean, obviously, this is quite a new agenda globally in terms of public registers, and so I was discussing with BVI Finance the scope for taking quite a leadership role in actually determining how best public registers can operate. As you say, we want to have a level playing field, so we wouldn't seek to impose greater strictures than in the UK. But I think, as this is at quite an early stage, there's the scope for the overseas territories actually setting a bit of a direction for everyone. In terms of the Crown dependencies, as the Minister says, they weren't actually included in the legislation, but we're certainly seeking to encourage them to do these sorts of things, and we'll seek to engage them in our technical working groups as well.
Can I follow up with that? Just a quick question. What will you do if there's asset flight, capital flight from the overseas territories?
Well, I think there's a competing sort of challenge here. At the moment, we haven't, as I said, Mr. Chairman, seen evidence of that. But it will, we are obligated as a government to fulfil the legislation that is required. Equally, the point Mr. Rosendale made about a level playing field, I've been very upfront. I do not think it will exist globally by 2023. So there is a risk that there will be some asset flow from certain territories to others which have a more liberal regime. As yet, we have not seen evidence of that.
Okay.
And just to add that there's certainly a broader agenda we have around supporting the territories with economic diversification, and I know that quite a lot of the territories are thinking about this. A lot of them, being small societies, tend to have reasonably undiversified economies, unsurprisingly, so we're seeking anyway to help them. Now, obviously, we're hoping the scenario you set out won't happen, but we're trying to see what more we can do.
Okay. Can I move on to ask about a different question? In the relationship to same-sex marriage, your submission says that change in the 5 Caribbean overseas territories is notably slower than the other overseas territories which have already legalised it. How long are you going to wait before intervening?
Well, the thing is, we've been clear about where we stand, and a particular case in question at the moment is Bermuda. And what we're seeing there is its due process and judicial process is currently taken. And I think that is the right way of ensuring what we've seen the courts is standing up for the rights of all citizens and standing up for the rights of the law that was originally passed. And I think it is right we see the outcome of that due judicial process. At the moment, there are no plans to intervene or interject or introduce an order in council to that effect.
But have you considered what will happen after the Privy Council process?
Well, the Privy Council appeal, I think we will consider what will happen after that Privy Council process. However, from what I've seen thus far of the judicial process, and just to add, if I may, when I met with the Premier of Bermuda, again, I made my own views very clear, the position of the government very clear, that we do expect progress on this particular issue. His response was very clear that it is now subject to a judicial process, and they're, as a government, awaiting the outcome of that. In terms of the other territories, Mr. Chairman, I think we've equally, in all our bilateral meetings, be it official level or ministerial, made this point regularly and consistently to all the overseas territories. Their view, I'm sure they may have also extended this opinion, is that they feel that it is an issue which they wish to reflect and move on in their own, respecting their opinions of their own citizens. That's something that they've expressed repeatedly to me. I don't know if Mr. Merrick wants to.
No, I agree with what the Minister says.
In that case, I'll ask Mr. Bryant to come in.
Do you mean that what I find difficult about Bermuda is gone to such lengths? I mean, it's lost repeatedly in the courts, and now it's trying, another 2 goes. First, the right to appeal, and then the Judicial Committee of the Privy Council. That seems an extraordinary amount of energy just to stop people marrying, doesn't it?
I agree with you.
And is it your take that they just they don't mind being forced to do it in the end, but they but they will have to be forced.
I think it varies from territory. The one strong opinion I get is that, coming back to a point we discussed earlier, this whole issue of the sanctions bill, there's been a lot of discussion on constitutional overreach because of that particular issue. What we've been clear that we would only use that particular order in exceptional reasons, as I've also made clear, I think, on this particular issue. My view was very clear that we shouldn't have proceeded down that way, but the will of Parliament has ensured that we now have to fulfil that obligation. On the issue of are they just waiting to see what they can exhaust, I'm hoping that the outcome will be that the judicial process, in this case in Bermuda, will uphold the original decision, and that will act as in a way, as a catalyst for other territories to look at long and hard at what decisions were taken, how law was upheld, and how they should act in accordance with that.
And just to be clear, you mean by uphold the original decision, you don't mean the law that the government tried to pass. You mean that the decision of the court
prior to them implementing the referendum. Yeah.
Can I go on to the question of belongership, which is something that for many has exercised quite a lot of thought and anxiety, because it appears to create, or in fact does create, very clearly two classes of citizen, even within a single jurisdiction. And it does appear to violate the UK's international human rights obligations and its role as promoter of democratic values. In the 2012 OT's White Paper, the FCO said that it was wrong to disenfranchise non-belongers, as they would have it. Is this still your position?
And the principle of the White Paper remains the case, but equally the issue of belonger status, I think, again, the territories feel very strongly upon this, that it's an issue that they should be ruling on. I think we've seen some movement in certain territories where they've changed the name, so they're no longer calling themselves belongers, and they've changed. But I think that's a technical.
I'm not sure this is an argument about the name. This is
no,
about the status.
In terms of their stuff, our view has been clear, but they've been very. Their pushback from them is that this is a matter they should deal with domestically.
And immigration is a devolved matter, so similar to the previous conversation.
Sorry.
So I was just saying immigration is a devolved matter in terms of the Constitution, so it's similar to the previous Constitution. Oh, I'm sorry.
Sorry, the question, though, as we know, is it's not just about residency, it's actually about having civic rights, like voting. It does seem odd in what we call the British family to have two classes of people. Would you not agree?
Yes.
Do you not think this is something that the UK should...
My view, Mr. Chairman, is that I think we have what I would call at times challenging, but a constructive relationship with the overseas territories. I've sought to create governance structures and communication channels which allows now for us to have some of these challenging discussions in a more constructive way. And I'm hoping that we will see progress in due course, but I'm being, again, very upfront with you in the exchanges we've had to date. Their overseas territories are very clear. They feel very protective towards this. They regard it as a devolved matter which they are responsible for, and they want the British government to respect it. But our position in the 2012 paper hasn't changed.
Will you be intervening?
Sorry?
Will you be intervening?
No, I have no intention of intervening in any sort of direct ordered way. I believe there is a great benefit to be had from having constructive progress, and I believe that, and I hope that there will be progress in that respect from the territories.
Do you think the UK should adopt a belonger status with British overseas territory citizens?
No.
You don't think we should remove their right to vote?
If they're registered to vote here in the UK, part of the British.
But they don't belong.
So the concept you asked an earlier question, do you believe in it? And as I said, I believe in what we stated
in the 2012
paper.
You know, this horse is goose, and
I think just because there's a wrong on one side, you don't create a wrong on the other side to try and correct it.
But you're willing to allow it to run?
I'm willing to have a constructive discussion to address it.
Mr. Austin, I shall ask you to pick up.
When Sir Simon MacDonald came to speak to us recently, he told us that extra funding is going into governors' offices. Could I ask how much this will cost, and how will you judge the impact of this?
Yeah, sure. I'm afraid I haven't got the exact detail. I can certainly provide that to you if that would be helpful.
Okay.
Yes, it relates to further support we're providing to sort of beef up the support within the Governor's offices. We're just finalising that now. I don't have the precise figures, but I'm happy to come back to you.
Okay, fine. All right, well, yeah, if you write to us, that would be very helpful.
Sure.
Could I ask as well whether the BVI accepted the government's offer last year of a £300 million loan guarantee?
We've been in discussions on two fronts. There was a £10 million contribution to the BVI and also the £300 million loan guarantee. On both fronts, yes, that has been accepted in principle. But part of that agreement was that we required the BVI to set up a special body which was geared towards reconstruction, a development agency. And that has been created through legislation within the BVI, which allows those funds to be channeled and to ensure that we address the concerns that certain private sector donors had for any funding that may come through. And indeed, the Caribbean Development Bank also had about directly providing that finance without having an RDA in place. So the short answer is yes. And if I may, Mr. Austin, specifically on that, we've also already seen some delivery. When I visited BVI, one of the direct contributions we made was a courthouse, which we delivered, which is state-of-the-art, which withstands 200 miles per hour winds, and was at a cost of $437,000. And that was well received by, obviously, the BVI government as a direct example of British assistance. And what I'm scoping at the moment is to see how we can take what is obviously a bricks and mortar building and how that can apply, for example, not just the BVI but other territories in terms of schools, shelters, housing. Because I think we have got not a perfect fix, because you never know what Mother Nature may actually present, but there is now scope to actually provide buildings which are resilient. And I think that should be a focus of some of the direct spending. In terms of the £300 million loan guarantee, the RDA and the governance structures, and we'll be happy to provide details of how the RDA will work, will ensure that the monies are actually funneled directly towards reconstruction projects in the BVI.
Thank you.
And just to add to the Minister's point, the Recovery and Development Agency is well underway and it's got its plans and so on. It has taken longer than we might have liked, but certainly the Premier was very clear from the outset that he very much valued the £300 million of loan guarantees. And part of the support we've been giving, as well as the physical things on the ground, is the technical support to set up the agency and, for example, technical support around debt advice and so on, to make sure they're actually planning for the long term as to how they will then repay the loans.
Thank you.
Mike, you wanted to come in quickly?
You were asking about the longer issue, but there is another issue which is affecting a number of people who were born illegitimately, with a father from the British Overseas Territories, and have a status which is not the same as people born more recently. I know that a number of questions have been asked in the House of Lords about this, and also I think the Joint Committee on Human Rights also sent a statement, a report of some kind to the government. And Lord Ahmed, I wonder if you could give us a sense of, is there any progress on resolving that issue?
Well, I think, as I said earlier to the Chairman as well, I think we are raising these issues directly with the respective overseas territories. In terms of a long-term resolution, it's very clear that they want to be able to move on this at their speed and at their behest, because they regard this matter, whilst it's specific, and I understand the nuance of what you've asked, they still regard that as a matter which is devolved and for them to take forward directly themselves.
Some of these individuals are in a not very good position because of this, and their status is unclear, and it's been going on for several years. Isn't it time we resolve this? Did you raise it at the Joint Ministerial Council?
It wasn't raised in the wider agenda, but these matters have been discussed in the bilateral meetings during the Joint Ministerial Council week. Whilst there is the general agenda, we also have bilateral meetings with the respective territories, and that's where these specific issues are raised. What I may suggest, Mr. Gapes, if there are specific cases, I'm quite happy to take forward quite specifically if there are particular cases, and because of the nature of the relationship I have and the officials have, I would be quite happy to follow up, but I add the caveat that they feel very strongly that such issues do constitute a devolved manner and that they should be moving on.
Can I, sorry, forgive me, just jump in for 1 second. The 1981 British Nationality Act is an act of the UK Parliament.
Mm-hmm.
Why is it devolved? In what way is it devolved?
On the issue of belonger status.
No, citizenship.
You're talking about citizenship.
But you're right as far as I can't dispute the act. I'm not sure when the cases.
I'm not sure. I think
Mr. Gapes was talking about citizenship by defence.
Look, I'll give you a specific example. For Montserrat, you can qualify British Overseas Territory citizenship of Montserrat if your parent is a mother of a legitimate or illegitimate child, but only if your father was of a legitimate child. So if the father is in a different position, and that therefore affects a child born in that relationship, and it therefore is discriminatory, and the Human Rights Committee Joint Committee has raised it with the government, and that does relate back to the legislation, but it is interpreted within Montserrat in that way. And that's the point. There are individuals whose status cannot get the British Overseas Territories status because of the fact, the accident of birth.
Yeah, if I may,
please,
both to Mr. Gapes, my understanding is it's an issue, you're quite right, has been raised. I know Home Office colleagues are looking at this issue, but because of the technical nature of that, may I, if there are specific cases...
But you can write to us.
I will write, excuse me, I will write to you, but I am aware, as I said, it's being looked at by our colleagues in the Home Office. But I will write to you because it's quite specific categorisations you're talking through, and I think it's best I write in this respect.
And well, I have, just to say, I have an email from a man in New York, I'm not going to give his name, who refers to him, at the end of his email, he says, a child, now an adult, of descent, born out of wedlock to a British parent of Montserrat.
Okay.
It would be
noted.
And he asked me to raise this issue.
And I've noted, and we will respond.
Thank you. Royston.
Can I, Lord Ahmed, take you to some of the other evidence that we received in our last session, actually. The Chief Islander of Tristan da Cunha told us that a £90 million harbour is vital for its very existence. Should the UK government pay for that?
Yes, I mean, certainly it's something we have worked very closely with Tristan da Cunha on, and indeed a lot of the other territories, particularly where there's an ODA eligibility. I think there is obviously an ambition to support, but at the same time, I know that the Department for International Development, who are lead on the ODA support, have been considering what the options are, because obviously that's a sort of significant amount of money as a proportion of the whole. So they are considering, what the best ways to achieve that support for Tristan would be.
If I may add to that, Mr. Pep, there are various capital programmes that we receive quite regularly from various overseas territories, including Tristan, as you've pointed out. And previously and historically, it would be fair to say we haven't perhaps looked at it as a complete overall government approach. Most recently, I've had very constructive discussions with the Secretary of State for International Development to look at the whole issue of ODA funding for our overseas territories and to look at longer-term capital programmes and support. In terms of Tristan specifically, the current harbour, one of the capital programme requirements was for its repairs and support, which we have extended, and we have done so, but more long-term expansion programmes, we have to look in the overall budgeting of ODA. But I can assure you we're having quite detailed discussions, not just in terms of Tristan, but other territories as well in supporting long-term capital programs. A good example of that is Montserrat. We've considered very carefully their requests over over the last certainly year or so since I've been in office, together with my colleague Lord Bates, supported by Secretary of State Penny Mordaunt. We've been very focused, and most recently we've agreed both the support of a extended port in Montserrat, and we're also at the moment working through the detail of a £30 million plus programme supporting infrastructure as per the requirements of Montserrat. That doesn't mean their requirement, I think, when they're about 50 million. So as much as we'd love to provide exactly to the penny the support each territory requests, it's not always possible, but we are certainly, the view we're taking is a much more long-term support of capital projects in each territory.
It's already had an investment of 7.8 million, which would be potentially sunk and wasted in the event that that was spent to, you know, keep things going, but there was an investment in the harbour itself. So is that taken into account when you decide what you're going to allocate in the future, what you've already invested along the way?
No, what I was going to say is that, yes, I mean, in the context of a business case, we look at these things very carefully from an economic point of view and obviously a developmental point of view. So, yes, I mean, we need to make sure that taxpayers' money is used properly in this context. And that's part of the thinking that DFID will have as working through the potential options for that harbour support.
Okay. Can I move on to another territory, Ascension?
Did you want to come straight in on this one, Andrew, or did you want...
On that point, sorry. Okay. The reality is that Tristan da Cunha, if there isn't that harbour, you're looking at potentially catastrophe for that territory, potentially having to depopulate the island because supplies just couldn't come in. So why is it taking so long? Why is there so much foot dragging on making what is essential decisions for the long-term existence of that island? Similar arguments can be used for Montserrat and the years it's taking to get that territory back on its feet following the volcano. Surely the FCO should be ring-fencing money from DFID to spend directly and quickly on these things in order to let these territories survive and actually be self-sufficient. Surely that's a better long-term policy than to delay and drag it out for years and leave so much uncertainty when in fact you could help the territories become self-sufficient.
Well, first, on your final point, I think that's the end objective, that we should be looking at how we can help territories become self-sufficient. Taking the specific example of Tristan, whilst there is this capital programme, and as I said, that has to be looked at in terms of the overall request for capital funding that we do get. The last capital programmes were finished in 2017 on the harbour. That doesn't preclude other investments to help their economy. We've invested monies, for example, in their fishing patrol through the Blue Belt money programme that we've allocated, and that's helped to not just protect but actually develop and strengthen their fishing capacity as well. So, you know, I'm sure those people around the committee who are keen lobster eaters will appreciate Tristan lobster. So I assure you, Mr. Rosender, the end objective is shared. And on Montserrat, for example, I alluded earlier to the £30 million capital programme. I've been very clear, I believe, when I was at this committee possibly a year ago on this issue of the overseas territories. One of the commitments I gave, it was probably a shorter time than that, was that proactively we were looking at opportunities. And in that respect, when I visited Montserrat, I took with me members of the British Caribbean Chamber of Commerce, the British Caribbean Council, and also a company, a bottling company from Yorkshire, who were a middle-sized family company, with the end objective to build sustainable industries. Why did I do that? And I'll be very honest, I Googled and found Montserrat had the most natural water supply, and there is a current small business which I've actually got recently an update because of the contact we established between the Yorkshire Water Company and the Montserrat Water Company. They now have secured new contracts. Because of the facilitation through the Caribbean Council, they now have new clients lining up. There is a relationship through a bilateral meeting I held in Antigua to seek Antigua's support for Montserrat in terms of access from Montserrat Post. I list that as a practical example that we're not only offering capital program support, but actually professional support in helping their respective industries and economies to build for the long term. And I share your objective that ultimately, if one was to say, what do I aspire to as the Minister responsible for overseas territories, is to create economies which are self-sustaining and growing to the benefit not just of the territory, but to the region beyond.
Thank you, Chairman. Ascension, Lord Ahmed, I was talking about when the Ascension island government came in last time, they told us that the island is likely to go bankrupt by 2024. Do you have any plans to do anything about that?
Well, first of all, we're working very closely with Ascension, and you'll understand the Ascension structure, governance structure, is also they themselves, because they do not have status of the right to abode, does preclude them from ODA funding, but they're part of the St Helena family. So I think in terms of looking to the long term, I'm very keen, as I've said to the Ascension Island, to St Helena, on looking at long-term governance structures across different territories to make them sustainable. You'll also be aware Ascension Island, because of its specific defence capacity, particularly with our alliances with the United States, it has a special status. I'm working very closely with both Lord Bates and also the Minister for the Armed Forces, Mark Lancaster, to see what long-term options we can actually build to actually address and counter the situation you've just raised. Because it is important. Is Ascension, I think the first question, is Ascension important to us strategically? The short answer is yes. Where are its main interests in terms of what it actually provides? It's strategically an important island and facility for us and for one of our closest allies. And in my mind, it's not for me as the Overseas Minister, Territories Minister, to look at it alone. So we've been working quite closely on its long-term future with both DFID and MOD, and certainly part of those discussions have been updating the islanders on progress in that respect. Have we got a final outcome of what the future of Ascension would be? The short answer is no, but we're certainly looking to avert any kind of situation which would arise, as you illustrate that. We certainly do not wish for the island to be bankrupt, and we're looking at various options with colleagues in both the MOD and DFID to ensure its long-term sustainability. But in my mind, what needs to happen, coming back to an earlier point, we have to be very clear what is the long-term objective of the island, and in doing so we have to look not only at all the interests on the island, but its governance structures as well.
And just to add to the Minister's point, that obviously the US government are an important stakeholder in this, and I met recently with my counterparts in the US government. As the Minister says, we've been acutely conscious of the challenges in Ascension Island for a long time. It is a very important asset, and as the Minister says, it's partly about governance, it's partly about infrastructure, and it's partly about the whole fiscal framework for Ascension Island. So we're absolutely clear that that has to be resolved.
Is it your understanding that the air bridge will go through Ascension once the runway repairs are carried out?
Yes.
Which currently goes through Cape Verde. So that's a given that when that's done, that will continue.
Yes, that's right. And in fact, the Ministry of Defence are jointly funding the Wide Awake Airfield repairs with the US government, and are closely involved in that at the moment.
You talked, Minister, a bit about the Blue Belt. Is it your intention to fully fund the marine protected zone around Ascension as part of the post-2020 Blue Belt programme?
To fund?
Yeah.
Well, I mean, our programme at the moment, the current Blue Belt programme runs until, on MPAs, till 2020, and the commitment we've made is for that particular funding round. What happens beyond 2020, that's part of wider discussions we will have. But I think if I can add, that is certainly my view, the MPAs, particularly around our overseas territories, not just talking in terms of Ascension, but whether it's about protecting natural habitat, whether it's about building sustainable industries, and also the general challenges around climate change have been extremely successful. We've had circa about 4.3 million kilometres of territory which are now within the marine protected allocation, and I think we need to ensure that we work with, first of all, the administrations in our overseas territories to see how MPAs first can be applied, and then importantly also enforced. It's no point just creating an MPA and not being able to then enforce the MPA in terms of its operation.
And just to add a couple of points to the Minister, as you say, I mean, marine protection is extremely important, and I think the overseas territories are a huge asset in that sense. I mean, it takes different forms in different places. Some in places it's specific MPA, and other places might be slightly different, but the broad effect of seeking marine protection is very important. In terms of the funding point that you raise, we will be engaging very closely in the next spending review taking place, I think, next year, around how we achieve long-term funding. But we do want to have sustainability. So part of that is about how to make sure that feeds into the long term, and we will be discussing, amongst others, with Ascension Island how best we take that into the long term as well. Because, as the Minister says, it's partly about the management, the monitoring, enforcement, and so on. So there are a number of strands to take into account.
Andrew, you wanted to...
question,
no? You wanted to...
Oh, the next. We're moving to the next one. Okay, great. Thank you, Mr. Chairman. So, moving on to a different topic entirely. Some of the overseas territories have said to us during the course of this inquiry, and from my own experience, this has been discussed quite vociferously over a number of years now, about where the overseas territories fit in terms of government departments. I know they've been admirably looked after by the FCO for a very long time, but Minister will understand when I say that this is a throwback from the old colonial office. Of course, we don't have colonies anymore. They are self-governing British overseas territories which really should be treated equally as part of the British family. So in today's context, is the Foreign and Commonwealth Office the right department for them going forward, bearing in mind they're not foreign and they're actually not Commonwealth either, because they don't have any status in the Commonwealth in their own right. So isn't it time to consider whether they should fit in a different department, maybe the Cabinet Office or somewhere else in government, but somewhere where they have specialist dedication to them in terms of the overall context of UK government rather than an add-on to the Foreign Office?
Well, I think you're right to say that at the moment they obviously sit within the Foreign and Commonwealth Office, but I think having a designated minister for the British overseas territories, and I would say this, but is an important role, but it has to be attached with understanding the nature of how each territory works. First of all, there's no one-size-fits-all in terms of your approach. In terms of where ultimate responsibility should sit, I think that's less important than what the approach of Her Majesty's government is. I've sought to create a vehicle, and the JMC is reflective of this, to have very broad representation from across government. So I agree with you, Mr. Rosender, in, for example, when we are talking DEFRA issues or environment issues, the DEFRA Minister, Brexit, which I'm sure a few of you have been occupied with recently, as have we, has meant that I'm very grateful to Minister Walker, who has been consistently supporting all matters relating to Brexit. Equally, Minister Chloe Smith came to discuss matters of the Constitution. Regrettably, we were going to have a meeting with the Prime Minister, but events that day didn't allow for it, and the same with Mr. Liddington. So I outline all of that, and of course the Department of International Development and MOD also feature. Is that the approach we've taken at the Foreign and Commonwealth Office, and we can have a debate as to where the point person should be. But I think it's the overall approach of the government should be cross-government. And certainly we've installed that mechanism and governance structure in our dealings with the overseas territories. I would also add a couple of additional points. One, what benefit has it been? Has there been any benefit from having a minister responsible in the Foreign and Commonwealth Office? Two short answers in that. I'm also Minister for the Caribbean, and those territories that are engaged in the Caribbean, I'm in producing and working on our policy and programme and strategy for the Caribbean. I've made sure that the overseas territories are included within that by sheer geographical location. That's important, and I think that has been a benefit of having a focus on the Caribbean where certain territories are, to ensure there is also a regional focus and they are included within that. You raised the issue of the Commonwealth. I certainly, as Minister for the Commonwealth, ensured that, again this year, when we held the Commonwealth Summit, that the overseas territories had a voice and a representative voice through their chair at various meetings that took place and receptions that took place as part of the Commonwealth Summit. And I think that was also a benefit to Premier McLaughlin, who attended, because there was scope to extend relationships through bilateral meetings with various countries of the Caribbean. And the way I'm taking this forward is that I feel very strongly that both as a minister, and I don't just include myself in it, but others as well, when we go and talk about the British family, that is inclusive of the British overseas territories, and having geographical ministers responsible for different parts of the world should add a complement to representing the overseas territories' interests in respective regions, and that's the view I have.
So could I just add to that, Mr Chairman? Can I just say I accept everything the Minister said. I actually like to commend the Minister, because I have witnessed over the last few years substantial changes which have made the overseas territories feel much more included in many areas, and the Minister's played a big part in that in recent times. However, looking long term, we're talking about global Britain. We're talking about the remaining 16 former colonies which now want to stay part of the UK family. Isn't it a bit more than just putting better arrangements in place and including them at Chogham and things of that sort, which is very important? Shouldn't we have a more secure position for them going forward? Future governments may not be quite so sympathetic as the Minister is towards the OTs. Isn't it time we gave them a more secure location within the arms of government to ensure that they are treated properly and equally and fairly long term, rather than the potential of perhaps what we've seen before, where different competing interests have led to things like proposals for joint sovereignty over Gibraltar, which was not supported, and other issues that we've seen as well. Isn't it time to modernise the status they have within the UK governmental structures?
On that, if I may, and Mr Merrick may have a perspective on this. First, I think looking at evolving ways of doing things is helpful and healthy. I think if we get static and stuck in our approach, be it through policy or governance, then I think we're not making any progress. What we have seen at the Foreign Office, for example, the Secretary of State has recently signed off on a joint ministerial group which will be established as part of our relationship with the overseas territories, which will include all the departments I've listed, which will be jointly chaired, coming back to the point that Mr Smith raised on the issue of capital programmes, will be jointly chaired by the Secretary of State for International Development, which will ensure that long-term future and focus for our overseas territories in terms of not just their engagement, but ensuring they're part and parcel of ensuring they get the right person and the right outcome in terms of the issues that they're raising with us. So that governance structure internally within government is already underway, and that's something I've been pushing, and I know the Secretary of State has recently written out in this respect to establish that as a way HMG will engage with our British overseas territories. Ultimately, if the British overseas territories have a view on where they feel their interests are best served, of course, in terms of the constructive nature of the relationship we have, I would certainly be willing to hear and see how they feel that relationship should be stronger. And I think you mentioned the Cabinet Office. The Cabinet Office are part of that intergovernmental ministerial group. DFID are part of it. MOD will be part of it. And the whole intent behind that is that this isn't, there may be a coordinating point, and I still retain the view that it sits well in the FCO for the reasons I've given earlier. But at the same time, the FCO has a facilitation role in ensuring all the other government departments are engaged directly in the governance structures we set up with HMG and the OTs.
So one very quick final point on this subject. Could the Minister therefore explain fundamentally what's the difference between Crown dependencies and overseas territories? They neither are constitutionally part of the United Kingdom. They're both external to the UK in that sense. So why aren't they both together in one department? Why is it that we treat overseas territories, still as if they're colonies in some senses, being from the former colonial office, but the overseas territories are treated one way, but the Crown dependencies are treated completely differently. What's the logic behind that?
Well, I think that whatever the historical reasons are, I, from my own personal perspective, believe that the Crown dependencies and overseas territories should sit within a single department. The fact they don't, and whatever the Mr.
Do you think they should sit within a single department?
Yes, I do. Because I think it allows for more effective coordination on a range of different issues, even if there are different perspectives or different policies which may apply.
So does that mean the Crown dependencies going in with the Foreign Office, or the overseas territories going in with somewhere else?
I think that's a wider debate to have with other parts of government.
Interesting.
I don't know if Mr. Merrick has a
Yes, I mean, certainly in terms of your original point, Mr. Rosendale, about the overseas territories, the Minister is absolutely right about the importance of coordinating the UK government effort as a whole, and there are potentially different ways of doing that. I think there are definitely some advantages about the Foreign Office as a base for that. For example, some of the territories we work with in a very sort of international basis. If you take the Falklands, the relationship between them and Argentina is very important, but also the public diplomacy we've done on behalf of the Falklands within South America. If you take the Cayman Islands, and we're actually supporting them expanding their business interests out into Hong Kong, for example. And we're able to use our embassy and consulate platform and indeed High Commission platform around the world to support the various sort of requirements of the overseas territories. Equally, for things like disaster management, I worked side by side with my Director Americas counterpart, who covers the independent Caribbean, because for Hurricane Irma, that was obviously a region-wide issue and so on. And there are a number of areas where, when we're actually looking to work across government, whether it's on global marine protection or other issues to do with, let's say, financial services or other things, when it actually worked quite well, I think, to coordinate the views of government and indeed the programme delivery through, whether it's disaster management or prisons or all sorts of other things, works quite well through the Foreign Office systems. So sort of very open to different ways of doing things, but I think it does work quite well at the moment, particularly when we're seeking to deploy governors and their office staff to overseas locations. And that's obviously sort of part and parcel of being in the Foreign Office in a way which isn't necessarily for other parts of government.
Thank you. Mr. Murray.
Thank you, Chair. Can I just ask a quick question before I move on to governors? How much, what level of time, what percentage of your time, ministerial time, do you spend on overseas territories, would you guess?
It depends on, first of all, it can be issue driven at time. Obviously, when the hurricanes hit last year, there's a substantive amount of my time, not just my time, indeed, many other ministers' time. But what I seek to do is have regular conference calls with them, and by regular is to try and at least speak to every overseas territories premier at least once every 2 months to have a proactive agenda on issues they want to raise. Of course, with all the best intentions in the world, and I'm sure you had the Chief Islander when he visited, he told you about the logistical challenges of visiting each particular territory. As much as one would want to do that, it's not possible. So I think the engagement and communication is important. So in terms of the normal course of business, that's what I would seek to do. I certainly, on every visit the overseas territories premier makes to the UK, we will always allocate time in advance of that. So the time could constitute an hour or two's meeting where we'll be discussing issues of substance. Specific example, if I may, Mr. Murray, I mentioned the Cayman Islands and Constitution earlier. I made sure that, notwithstanding other challenges, that I engaged directly with the Premier through a bilateral meeting which lasted an hour, and then, of course, the detailed technical process was taken forward by the officials over a course of 2 days, and then I joined the meeting at the end of it to see what other support I could extend to it. So it really depends. It can be issue-driven. But what I've sought to do is set up regular communication channels to ensure that I can not only represent their interests across government, but also hear and listen to their concerns directly.
Okay, can I go on to ask you a few questions about governors? What advice and training do you give to governors before they're posted to overseas territories?
We give a considerable amount of advice and induction training to governors in advance of their deployment, and obviously depending on when they're actually appointed, we usually try and start very quickly. Now, what we're seeking to do is to actually establish a much broader cadre within the Foreign Office and elsewhere to actually enable more of a sort of career path for governors, but certainly there's a lot of support. There are sort of specific courses we do, whether it's about disaster management or financial management and so on. There are broader developmental courses, issues to do with running an overseas mission, for example. And then clearly there's a lot of territory-specific issues as well, and so we will clearly brief people up substantially on that. But also what we seek to do where it's possible is to actually get future governors to another of the territories in advance. Obviously it depends on logistics and so on. Also, one of the things we do is I establish a sort of broad community of governors and the policy community in London. So actually we have a sort of support network, if you will, on policy issues and other practical issues between governors to make sure that as and when new governors arrive, they're sort of very much supported and aware of the key issues. And so on.
None of the 10 current governors that have been posted in overseas territory have been posted there before. How do you assess their effectiveness and whether or not they're in the appropriate place and the appropriate job?
Yeah, well, again, the reason I'm not, because Mr. Merrick is the responsible line manager, so in Mr. Merrick you have the right person in terms of officials.
Thank you, Minister. Well, obviously, we take a normal sort of performance management approach. We set out the job descriptions for the particular posts, and indeed we consult the territory governments in advance in terms of the kinds of attributes they would want for their specific governors. We go through an interview process, as you would expect, and scrutinise that carefully. I then performance manage the governors, so we're clear on the key objectives that we need to achieve. We will go through the normal procedures of things like sort of feedback and performance from a range of people within the territories. And I engage closely with all the governors on an ongoing basis in terms of supporting performance in whatever way is necessary. So, as with any of my colleagues, we take things forward in a proper performance management approach.
And under what circumstances would the Foreign Office make the decision to withdraw a governor from an overseas territory?
It's very rare for that to happen. It would depend on the circumstances at the time. If there were particular reasons why we felt it wasn't possible for a governor to stay, then we might consider that after due process and proper investigation and so on. But it's extremely rare that would happen.
And finally, Chair, if I may, the quality of the overseas Foreign Office staff that certainly I and this committee have come across the world have been outstanding. And there is no doubt that the missions in various countries across the world, whilst they have mixed ability, all do a fantastic job. Are you confident that the governorships in overseas territories are given the same priority in terms of the quality of staff and management that's put in place as would be any large mission in, say, China or Washington or Berlin?
Yes, I'm very confident. I think we have an excellent set of governors. I often say to people that I have one of the best jobs in the civil service because I get to deal with such a range of extraordinarily important and interesting issues, but also to work with excellent people, both in the territory governments and their representatives in London, and indeed the governors as well. Our governors come from a range of backgrounds, but we recruit them under a proper disciplined process. Now, clearly, there are always elements where we kind of develop together, particularly as and when new issues arise, or indeed when disasters take place. But we have some excellent leaders. If I just take but one example of Governor Gus Jaspert in the British Virgin Islands, who's dealt with extraordinary challenges in terms of Hurricane Irma hitting about a fortnight after he arrived there. But he's demonstrated excellent leadership alongside the Premier of the British Virgin Islands across a whole range of issues. So yes, I'm very confident, and clearly the quality of leadership is very important to us. But also I think within the Foreign Office more broadly, people very much recognise the importance of the governor roles and indeed, frankly, the leadership opportunities that they represent. And our Permanent Secretary visited several earlier on this year and hopefully we'll visit some more in due course as well. So he's very much aware of the importance within the personnel process of getting very strong governors in role.
If I may just add to that, Mr. Murray, first of all, in agreeing with Mr. Merrick, I mean, I've experienced many governors on my visits and, as I said earlier, the meetings that we have with the premiers, whether it's through conference call or indeed in person, we stress the point that the governors should always be present. They have an important role beyond an ambassador, say, in a particular country, because they're the bridge between Her Majesty's government and the overseas territory. And I think one vital point, which I know Mr. Merrick and I discuss quite regularly, is the importance of the person in terms of their ability to communicate effectively and keep channels of communication open. Because the relationship between the Premier and the Governor is the most crucial relationship to ensure that the territory progresses.
Can I just very quickly say I completely agree with your assessment of Mr. Jesper, who has done an extraordinary job and very much has the thanks of the committee. Can I go on to Mike?
Yes, please. Lord Ahmed, following on what you've just said, isn't there another factor here that we need to be clear about, that these are very small territories with very small populations, so the Governor could actually know personally a very large proportion of the people, not just the decision makers, but the people in general. Isn't there a danger that sometimes they may actually be too reluctant to speak up when things are going wrong? And I go back to the previous, well, several select committees ago, when our committee sent a delegation to visit Turks and Caicos. And although I suspect the FCO knew that there were problems in TCI and allegations, it was not until the select committee went there that the government intervened and suspended the government there and imposed a direct rule, and subsequently, I know it's still ongoing, the Premier, Mr. Missick, was before the courts. Now, wasn't there, therefore, a lesson to be learnt from that, that sometimes the Governor, you said, has to have good relations with the Premier? They may be too close sometimes when there are things going wrong, or whether things are not as they should be.
I think, and this applies to all of you, I think, first of all, you're right on numbers. I think the Bermuda is probably the largest overseas. Cayman Islands, yeah, has just taken over. There's 60-odd thousand, which probably is less than each of your respective constituencies. And I think that emphasis I gave about people and the relationships you have is important. But I think it's the strength of a relationship between a governor and a premier, which allows, when it comes to very difficult issues, for that issue to be addressed directly. I mean, historically, you're quite right. I acknowledge that there have been issues with different territories which have then sought to be resolved, and we've learned from them and tried to put in processes which address them. But I do believe very strongly, I also use the term that they're a bridge between the government. There will be often occasions where there will be issues which the Governor will raise directly with officials or indeed the government here, which will allow us then to address it directly rather than the Governor being directly engaged. So it depends on the individual. If I can be, as candid as that, I think the individual personality of someone, and when you're dealing with someone day to day, inevitably you establish close working relationships. I would argue that they could both be with a positive impact, or they could have a negative impact. I think what we need to stress is that the Governor's role is quite unique. It's different to an ambassador's role, because they are representing British government interests and Her Majesty the Queen in that particular territory.
I understand that, but my concern is, and this is under a Labour government, so it's not anything to do with this current government. I'm concerned that although things were clearly not right in TCI at that time, nevertheless, UK government didn't intervene until the Foreign Affairs Committee highlighted the problems and published a report, which then led to governmental intervention. And I don't know, I can't say the reasons for that, but nevertheless, Foreign Affairs Committee isn't going to travel to every overseas territory on a regular basis, because we are, of course, responsible for 200 countries in the world, in a sense. The problem it would be if the governor is not strong enough, or if they don't have the status when they even if they express concerns, that the UK government doesn't take it seriously.
If I could provide some reassurance, I think I confess I can't really comment on what happened in the.
We're talking 10 years ago,
exactly,
9 years ago.
So no, I know about that one, but I don't know the detail about the governors at the time. But what I can certainly reassure you on now is that the sorts of issues you highlight are very important, but also I think one of the advantages of drawing people from the UK civil service is that my senior colleagues have already a lot of experience of operating in a political context, and we have close relations with political leaders and others. But for us, the civil service values around integrity, honesty and objectivity and impartiality are very important, but also the principle of speaking truth to power. And so we have a constructive relationship, but the governors, for example, are very clear about the nature of the Constitution and the nature of legal obligations and so on. And all of my governors will have a sensible, constructive relationship with their governments if they feel there are any problems. But also because we work so closely with our governors, we're having this sort of discussion on a weekly basis or sometimes more frequently. So as a result, if there are particular concerns, we will discuss it with them and with Lord Ahmed and potentially others, and therefore work out how best to address those sorts of things. So as I say, I can't comment on what happened a decade ago, but I'm very confident these days that this is the sort of thing that we would be on top of very straightforwardly.
Well, we hope so until the next crisis somewhere.
Well, if I could just add, I mean, it comes down to Mr. Gates, who's doing the job, frankly, and they're recognising all of us, in whatever job we do, have obligations that we need to, and standards we need to sustain. And I think Mr. Merrick and history, and I've seen it, there have been challenges, and without naming territories, personalities, there are issues which are sometimes brought to Mr. Merrick's attention. He will discuss those with me. We will then determine whether at that time it is more appropriate for a governor's intervention or an intervention from London, because sometimes about sustaining that important relationship. I think the governor makes a key judgment call. Is this something I can resolve domestically with the Premier, or is it something that I need to escalate? And when it's escalated, part of our job also between us is to sustain that relationship between the governor and the Premier, because that is a crucial one. In terms of what happens in the future, it will only be determined once we experience different situations, but we have learned from experience, and dare I say, it shows the importance also of the important work of the Foreign Affairs Committee.
Thank you.
A couple of very good points on the governors. We all want to have a sort of modern relationship with the overseas territories, and therefore isn't it time that the overseas territories were given a say about who their governors ought to be? Isn't it right that rather than just imposing someone who maybe you've chosen someone who's a perfect fit for that territory, isn't it time that we gave the overseas territories elected governments a real say in who their next governor is going to be? And secondly, for those territories who wish to have it, isn't it only right that the traditional tunic that the governors used to wear should be permitted where the territories actually want their governor to wear that outfit, rather than to take the funding away or expect the territories themselves to fund it?
Mr. Merrick, I'm sure, will come in on this. First of all, on the issue of say, I think certainly has been my view that we will take, not just necessarily the individual, but the type of individual that a territory is seeking in terms of the qualities, the capabilities, the competencies. And we do have that discussion with the overseas territories, and it's important that we not only nurture that, but strengthen that. In terms of formal process, as Mr. Merrick's the line manager for the governors, he will speak to that. On the final point about traditions and what they should wear and how they should represent, I myself am a stickler for tradition, and I think tradition is a good thing. And if there are certain traditions that need to be sustained and there's something valued by our overseas territories, then we should look at that and see how we can best facilitate. But equally, with all things considered when it comes to issues of resourcing, and I don't know what the cost is of a particular uniform or a particular tunic, but we need to ensure that it's relevant and reflective of the ambition a territory has, and if there's validity behind it, I think it's something we can discuss on a territory by territory basis.
Yeah, sure. In terms of the first question, the Minister's point about consulting territories on the sorts of attributes they would like to see is very important, and we always factor that into the job description and the way in which we interview people and so on. I think the way in which we do it works well. I think it's easier for us doing it on this level. I don't think we are imposing people. I mean, we're going with the sorts of people that they would want, that the territories have asked for, I should say. But I think it still works well having the approach that we take in terms of the interview panel and so on. In terms of the tunics point, I confess it's not something that anyone's ever actually raised with me. I'm obviously happy to look at it if other territories feel they would like to do that as well. But yes, we tend to respond when people raise these sorts of issues.
Okay, thank you.
Did you want to go on to the next?
Yes. So now moving on to a completely new subject, which is the overseas territories and Brexit. Maybe we should end on that.
Yes.
Clearly, overseas territories could be affected just as much as we are by certain aspects of our departure from the EU. So, Minister, could you please reassure the committee that the UK will be match funding any loss of grants funding the overseas territories currently receive from the European Union, at least until 2020, and what arrangements will be in place after 2020? And if there is a no deal, could you tell us what plans are being put in place today as we speak? Because this is, we are potentially facing that now. We need to have a plan in place to ensure that there will be any detrimental effects, possible detrimental effects, will be minimised for the overseas territories.
First of all, on the issue of European funding, the short answer is yes, and we've confirmed that, particularly on the EDF programme, which impacts many of the territories, and we've written to all the territories in that respect, confirming that within, if there is currently any programme one in any transitional period, that will continue in the consequences of a no Brexit deal. We've already agreed with the Treasury, and I'm grateful to the Chancellor for support in that we will also ensure that the commitments that have been given through those European funding programmes will be continued for the current cycle. In terms of no Brexit, in terms of leaving without a deal, leaving European Union without a deal, at this year's JMC, whilst we had a particular session with Minister Walker, we also, with one of the senior officials, arranged a briefing with the senior officials dealing with the issues of Brexit at the Foreign Office to talk through the consequences of no deal being arranged or no deal being agreed by the time we leave the European Union on the 29th of March. And the primary concern was, of course, much of the European programme funding, which we have given that reassurance to them. And they have also been assured that there is open communication on any specific territorial concerns they wish to raise directly with the government, be it through the Foreign Office or indeed the Cabinet Office. And I think the reflections of the Chief Minister in Gibraltar also were reflective of recent discussions we've had of his direct engagement on discussions that have taken place which are specific to Gibraltar. So the short answer is yes to the first question you raised about funding. That has been assured and that's been confirmed to them, both in terms of if an agreement is reached, what that would mean, but also if there were any implications of leaving without a deal, that we would fund any European funding programme for the current cycle till 2020.
Thank you.
What happens beyond 2020?
Well, that is part and parcel of the discussions we would have with any department, and I think that will be part of the funding discussions we have cross-government about budgets, programmes and departments. So that would be part of the normal discussions that we would have.
And the Cabinet made the decision this morning to implement their no-deal scenario planning. What are you responsible for? How much will it cost? And how advanced are your preparations?
Well, in terms of costings, etc., when it comes to the overseas territories, the immediate cost in terms of a no-deal scenario would be fulfilling the specific pledges which exist across different European programmes. In terms of the specific allocations, I'll write to the committee confirming what those are.
And could you write to the committee with your no-deal scenario planning as well?
When you say no deal with the overseas territories, we can certainly...
Or as part of your ministerial responsibilities elsewhere?
Well, the thing is, part of my ministerial responsibilities is ensuring that first and foremost that we get a deal that works for the overseas territories, and in that respect, as I said, we've been over the last year and a half been working directly with Minister concerned, and Minister Walker has been very courteous in his time and allocation to talk through and address some of the concerns. And the major concern, Mr Murray, has been on the issue of EU funding. But in terms of the preparations we're doing, the current work we're doing within the FCO, I'll be happy to update you.
Is there a specific no-deal scenario plan in place? Do you have something written down, a document?
Well, as I've already alluded, there's a practical example I've already given.
That wasn't the question. Is there a document in terms of your no-deal scenario plan?
For the overseas territories. There is a document that we've shared in terms of a session we held with the overseas territories, and that was, as I said, there was a senior FCO official who came to talk through that scenario. So is there a existence of a paper which talks through a no-deal scenario as a discussion with our overseas territories? Short answer is yes, because we did just that at the JMC.
And much wider for the rest of your ministerial portfolio?
Well, the thing is that, in terms of my wider ministerial portfolio, slightly beyond the remit of my appearance today, but I can assure you when it comes to areas of human rights, when it comes to areas of counter-terrorism, countering violent extremism, when it comes to the strength of our collaboration with the European Union on issues which I cover, I believe very strongly that irrespective of whether there is an agreed deal or no deal, that in the areas that I've highlighted, that we should work in a very closely and aligned way. And those are the sentiments I have in terms of our future relationship with Europe.
Sorry to go back to the point, but is it written down? Do you have a document, a no-deal scenario document for your ministerial portfolio?
I think specifically for every element of it, there's no no-deal scenario for every specific element of my ministerial responsibility. I'd be happy to furnish you with the details, as I said, about the no-deal scenario that we've talked through with the overseas territories.
So a document does or doesn't exist?
Well, with the overseas territories, I've already alluded to that. I think you're trying to ask a question which perhaps I'm not quite understanding what you're saying. If there's every element of what is a wide ministerial brief that
I suppose the point of the question is that in terms of the overseas territories project the inquiry that we are conducting as a Foreign Affairs Select Committee, a lot of the overseas territories are telling us how concerned they are about not just Brexit with a deal, but particularly Brexit without a deal. And the Cabinet this morning made a decision to implement the no-deal scenario planning. So I appreciate that you may have some kind of document that you can institute in terms of what a no-deal scenario would look like for overseas territories. And I'm merely asking if your entire ministerial portfolio has meant that you've had to produce a document that highlights everything that you're responsible for and what would have to be done in the case of a no-deal scenario.
Well, the thing is, it depends on which element you're talking about. The implications of a no-deal scenario wouldn't necessarily apply to every single element of how our
So in the element that it does apply to, do you have
which I've alluded to, for the purposes of this inquiry, I've already said that we've talked to the overseas territories to a document with a senior official from the Foreign Office. I think it's at the moment for me to say, if you're looking for every element of what is, freedom of religion or belief, I'm the Prime Minister's envoy on that. How does that shape in terms of a no-deal scenario? Have I shaped a specific no-deal scenario document on freedom of religion or belief? The answer is no.
Can you give us an example where you
there
have?
Are common values, if I may finish, Mr Murray, that we share on issues of freedom of religion or belief. And I will continue to work with the appropriate representative at the EU to ensure that we align ourselves, because we share a common values agenda. That would still apply whether we had a deal or we had no deal. And that's what I'm alluding to, that this is, it's a question that, to say that is there a specific no-deal Brexit scenario in every element of my portfolio, I think is not a question I can answer, nor should I have to answer, because on certain issues it should be immaterial whether we're members of the EU or not. Will we stand up for certain elements that we do as part of my ministerial brief? Of course we will. Will we have a closer working relationship with E3 member states as we've done previously. I think historically that will, and going forward it will continue. But I think it's beyond, I would suggest, most humbly, that the scope of the current report. In terms of the specifics of the OTs, I think I've answered that question.
Well, I won't push it further because the Minister's obviously doesn't want to answer the question. And it's
That's not what I've said.
Of the overseas territories
That's your interpretation, Mr Murray. I have answered.
Sorry, please don't talk over each other. Sorry.
No, sorry, Mr Chairman.
You either have a document for a no-deal scenario for the bits that is relevant to your portfolio, or you don't.
I think, as I said, I've answered the question as best I can, and in the context of the OTs, I've given a
So the OTs, from your perspective, the OTs are ready for no deal?
Well, the OTs, we've had discussions with them, and the JMC specifically. At the JMC, Mr Chairman, we had a discussion on the no-deal scenario, and we talked through the main concern the overseas territories have raised with us is on the issue of EU funding. And we've had discussions with the Treasury, and that funding is guaranteed.
Okay.
If I could just ask one final question. I promise this is the last question I shall ask the Minister today. We are commemorating 100 years since the ending of the First World War. Many citizens of overseas territories fought in Her Majesty's Armed Forces and still do so today. Yet, the overseas territories have never been allowed to lay a wreath at the cenotaph on Remembrance Sunday. We recently have started the fine tradition of inviting the Ambassador of Ireland to lay a wreath in recognition of Irish citizens who served in British Armed Forces in First and Second World War. Minister, will you take this back and maybe, as we leave the EU and global Britain, recognise the part the overseas territories have played in helping to fight for our freedom and democracy, and give them the ability to lay their own wreath or wreaths, depending on they do a joint one or one for each territory, at the cenotaph on Remembrance Sunday. I think as a symbolic gesture to them, it would mean a huge amount to the peoples of all the territories. There has been a block to this over many years now, and I would like to ask Ms. if you'd be willing to take this back and see if we can find a solution so that next November we can proudly welcome the overseas territories and watch them lay their own wreath to commemorate their own people that have served and fought for this country.
The short answer is yes, I'll be happy to take that back. I think there's great merit in what you suggest, and I'm not sure what the impediments have been, but I'll certainly look into that and take that forward. I think it's an excellent idea.
Thank you, Minister. Can I thank you both very much indeed for this afternoon's session, and thank the division bell for not having rung despite warnings that it might. Order.
Thank you.
The proceeding has ended. 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 The proceeding has ended.